Discrimination lawsuit filed by Arnold Dave Davis continues to move forward in the District Court of Guam in light of the Ninth Circuit Court's decision partially ruling in favor of Davis's challenge of Guam's political plebiscite. Here's more.
Arnold Dave Davis is continuing to challenge a political plebiscite, reiterating his claims that the decolonization registry violates his constitutional rights as a voter and citizen of Guam. He filed a motion for summary judgment, essentially asking the District Court of Guam to rule Guam's plebiscite law as illegal. But the Attorney General's office is firing back with its own motion for summary judgment, asking that Davis's lawsuit be dismissed. Although the lawsuit was first filed in 2011, the laws governing Guam's political plebiscite have been around for decades. It was created to give native inhabitants of Guam the chance to express their desires for Guam's political status with the President, Congress, and the United Nations. Only those eligible to vote can register. When 70% of eligible voters have registered, the plebiscite can then move forward, asking voters to choose one of three political status options they would favor with the United States: independence, free association, or statehood. When Davis filed his lawsuit, he claimed that his rights were violated based on race because he is not Chamorro. Davis categorically places the plebiscite law under the Voting Rights Act and further claims that denying him the right to register is racially based, as it only allows, quote, native inhabitants of Guam and their descendants to register in the decolonization registry. In response, the AG's office says this lawsuit has nothing to do with race. On the contrary, the class of citizens who hold the right to register include a multiracial, multi-ethnic group of people, namely the pre-1950 residents of Guam and their descendants. In addition, the AG's office says it is wrong for Davis to apply the Voting Rights Act to this lawsuit because the plebiscite is non-binding, meaning it does not effectuate any kind of law and it does not involve an election for public office or any kind of voter initiative or referendum. Quote, it confers no benefit or privilege, proposes or repeals no laws. It only seeks to ascertain the desires of a certain class of citizens. Thus, it continues, to equate it with a vote within the meaning of the Voting Rights Act is absurd. Davis acknowledges the racial component of the AG's argument, noting that what the AG is essentially asking for is for the court to declare that a longtime Guam resident, such as Davis, although not a native inhabitant, is somehow, quote, substantially less interested or affected by the possibility of Guamanian statehood or independence than a native inhabitant who has rarely set foot on Guam but whose grandfather received U.S. citizenship through the Organic Act. This, Davis believes, is nonsense. The AG's office disagrees, however, indicating that that class of citizens earn the right to express by plebiscite their desires regarding their future political status with the U.S. This right has been too long denied, the AG's office says. Attempting to disguise such an injustice beneath the cloak of civil rights is as shameful as it is transparent.
You can read more online at pacificnewscenter.com.